Good morning, councils. Sorry for the delay. The weather and everything else is kind of, and we have sickness in the my judicial assistants under the weather. So they let me run the technology. So that also added a few minutes of delay. So I hope that you don't hold that against me. But your proceedings are being live streamed over YouTube to satisfy the court's public forum requirement. Many of you here for status to begin with. And then for those of you that wanted to have hearings, if you have otherwise arranged for a court reporter, that's fine. But I don't know if Ms. Weaver's still on the platform or if she's available as of yet, but you can let me know when your matter comes up. A couple of things, if all of you who are on the platform, if you could please put yourselves on mute, that helps with the ambient background noise. I don't have to compete with that. And turn your cameras on. And if when I talk with you or call the case, we'll go ahead and then you can unmute yourself accordingly. All right, with that, let me go ahead and get started. Position one is Bashir versus Bashir. Mr. Chambers. All right. Mr. Kearns, have you heard from any of the parties in the Bashir matter?
Right here, Your Honor.
Okay, Mr. Chambers.
Yes.
Can you go ahead and
Yes. Yeah, man.
all right. Is that you on the iPhone?
Yes, sir.
Okay, all right. All right. Okay. And are you representing Lillian Bashir? Is that correct?
No, I am. Robert Chambers is, Your Honor.
Okay, all right. Is Miss Bashir here, Carla Bashir? All right. Mr. Chambers, when's the last time you talked to Miss Bashir? I think she's representing herself.
She is probably 3 weeks ago.
Okay, all right. Well, you're here for status. What can I do for you?
Well, we're down to this, is that the house that is at issue is to be sold. That was ordered a couple of years ago. What we've asked from Carla was evidence of the improvements that she claims was made on the house. She lives in it. And to date, I have nothing in terms of canceled checks, invoices. All I get from her is the name of someone who apparently had worked on it and the telephone number. Nothing. The issue is there's improvements that were made to the house while she occupied it and my client did not. All we want to know is who did she pay and how much did she pay? And she's not, to this point, been willing to do that.
Okay, did you file a motion for contempt or a motion?
It's sitting right here, about to be filed today, Your Honor.
Well, I think that would give me the ability to then answer those questions for you.
I certainly hope so.
All right, Mr. Kearns, when can we set it down for? Let's say, can we do that maybe about 30 days hence?
Let me check, Judge. We have Tuesday, 12 September available.
Mr. Chambers, that work for you?
No, it does not.
Okay,
There are two things clashing there already.
what's that, sir?
There's a hearing in DeKalb that's probably going to take quite a while.
Okay, what's the next available date, Mr. Kearns?
The next day.
Well, Mr. Chambers, I get to call my own calendar. I mean, you're not the only person. I have other people and other equities I have to meet.
Okay. Well,
Okay,
what do you have available, Your Honor?
Better question. Okay. All right. Let me see what I have. That's what I was asking Mr. Kearns to look for.
Well, Judge, let's see. The next week, possibly, if you want to take a look at it, Judge, I don't want to conflict with already scheduled matters.
And what day is that?
I was thinking Tuesday, the 19th. We could
Of Tuesday, the 19th of
September, Judge.
Wes, can we do it maybe the 14th at 8:30?
Of course, Judge.
Mr. Chambers, how about the 14th of September at 8:30?
That's excellent, Your Honor.
All right. Sir, we'll send, you file that and we'll send out a notice, okay, for the 14th of September at 8. In fact, you can put that in your notice and you can go ahead and file it and go ahead and send it out, okay?
Yes, I will.
All right, sir. You have any other business before me?
I have no further business.
All right, well then, thank you for your patience and we'll see you on the 14th of September. If you should work out your matter between then and there, let Mr. Kearns know. We'll mark you off the calendar, okay?
Okay. Have a good day, Your Honor.
All right, you the same. Okay. Next matter is Weathers versus Weathers, and I'm looking for Mr. Shoemaker, Mr. Oldham, Ms. Schuman, and Ms. Myrick.
Morning, Your Honor. James Lewis for Ms. Weathers.
Morning, Your Honor. Larry Oldham for Mr. Weathers.
Good morning, Your Honor. Eileen Schuman, the Guardian.
Okay,
Your Honor, we had requested that you hear this matter. We have a pending emergency motion filed dealing with return of the children and a violation of the temporary order. Judge, we'd like for this matter to be heard. We have a handful of issues to be heard. And we, per the notice, we went ahead and brought our own court reporter for this.
who's your court reporter? Mr. Carroll, all right, okay. Let me go ahead and cue this up and kind of tell you where we are, okay? So let me do that. We're here on the matter of Weathers versus Weathers in 2020 CV 339216. Now, parties, go ahead and for the purpose of the record, identify yourselves.
Your Honor, James Lewis representing Miss Esther Weathers.
Your Honor, Larry Oldham representing Seth Weathers.
And Mr. Lewis, you're the petitioner, and Mr. Oldham, you're the respondent. Is that correct?
Yes, sir.
Well, yeah, Your Honor, we have there's some different motions that are pending. So,
Okay, and then
The
I
motion
understand. Okay,
I'm sorry.
I'm sorry, Mr. Weathers. Complete your sentence. I apologize.
no, Judge, there are a number of pending motions and a motion to modify that temporary consent order,
Mhm.
an ex parte motion, which I guess it's not going to happen. It was an ex parte motion filed by Mr. Lewis on an emergency basis. There is a motion to maintain the status quo pending a hearing on this matter. And Judge, frankly, there's also Mr. Lewis had filed a motion to compel for some documents and other discovery responses. So we got a lot of different matters going on here.
You do. You do.
Yes.
But let me go ahead and account for the rest of the parties, okay?
Okay.
Ms. Shulman, good morning, Madam. You're the guardian ad litem.
Yes, good morning. Eileen Schuman is the Guardian ad litem this morning. Thank you, Your Honor.
Okay, and for the Department of Family and Children's Services, we have Miss Myrick. Do we have anybody here from DFAX?
Your Honor, I don't think DFAX is involved in these current proceedings.
Okay, I just want to make sure.
All right.
All right, but we're not want to count for everybody who's supposed to be here. Okay, folks, look, I know you all have a lot of pending motions here, and there's a lot of issues that are involved. I read the pleadings, and the courts of the opinion. I mean, a lot of people file emergency motions and make certain situations an emergency, but really it's not. I mean, in having a look at your motions that you filed, the court's opinion is you should go ahead and return the children, leave things the way they should be, let Ms. Shulman finish what she's supposed to finish, and then we can hear your matter. But people, a lot of times in these kinds of situations, one of the parties forces an emergency by not doing what they should be doing. And that doesn't dictate an emergency. You created one. So unless you can convince me to the contrary, that's what I like to do.
Okay, well, Judge, I mean, we're going to have to get into a lot of things, but basically Ms. Schuman has not done her job since the time she was appointed in this case. She's an officer of the court. and she has a duty.
But that's your opinion.
No, Your Honor,
That's
it
your
is, but I've got evidence to support that. It's not just my opinion. I got involved in this case very late in this matter, but I know for an absolute fact that this father has not had access to these children other than for 2 days every other weekend and 1 day during the week in a situation where he is a good father.
Okay, and we can iron out all of
Okay.
that,
I know, but Judge.
but we're not gonna do it today. And by forcing the issue and not returning the children, that's what
Yes.
you've done in this particular circumstance.
Judge,
So-
the kids are being emotionally and mentally abused.
I
We
want
have
the
evidence
children,
of
I
that.
want the children returned. I want Ms. Shulman to finish her evaluation, and then you can go ahead and have the court with improper
Judge.
form. Go ahead and do that.
Okay, Judge, do you understand? I mean, I know that this case just came back to you, but do you
Be
have?
be very careful, Mr. Weathers.
No, it's
Be
not.
very
Mr. Weathers.
careful about what you tell this court and the way and manner you tell this court.
No, Judge, I'm with you. This is Mr. Oldham. Okay, it's Mr. Oldham. I'm sorry. It's not Mr. Weathers.
Mr. Ullman, be very careful about what you tell me and how you tell me this.
I will,
because
Judge.
I've been doing this a while, not my first rodeo.
No,
And
okay.
certainly I sat in the family division for 4 years.
Yes,
And I practiced in the military for over 30 years in doing family law. So I do know a little bit about the subject matter.
Judge, I was not trying to indicate that you didn't. What I'm trying to explain to you is that there has been mental and emotional abuse going on with these children for a while. Ms. Schuman has known about it for.
Then let Ms. Shulman finish her evaluation and do what she's supposed to do. And then you can go ahead and we can go ahead and take up the matter at that point in time.
Your Honor, but we have an 11-year-old, a kid that's getting ready to be 11, and a 6-year-old that are being traumatized day after day. They've been with their dad since July the 6th because their dad found out that the mom was punishing them for spending time with their dad. We know this to be the case. They have been never.
Your Honor, I'm going to go ahead and object to all of
Your
this as the
Yeah,
court.
it's his assertion. Mr. Lewis, I understand. It's just his assertion. I'm telling you where I am at this point in time, okay? I don't have to necessarily get concurrence from everybody, okay? I'm
Got it.
just telling you that at this point in time, I'd like to let Ms. Shulman finish what she's doing, and then I can go ahead and hear everybody's concerns. But what the father has done is basically create an emergency, and I'm just not gonna go ahead and do that at this point in time.
Your Honor,
So-
okay, the only thing that I would say is the father has not created an emergency. We brought this.
And
to
return the child.
Wait.
Then return the child.
Your Honor, may I speak?
Then return the child.
Your Honor, may I speak?
Yeah, certainly you can
Oh,
speak,
okay,
but
okay,
but
and
I'm telling you, return the child.
All right, Your Honor. Miss Schuman, so this issue was brought to the attention of Miss Schuman. She refuses to meet with the children. Period. She said the only way that she can make any recommendation to the court is for us to hire a custody evaluator, which is, she said, I can't do anything. She's not asked to come see the kids. She's not asked to talk to the kids. She's not done anything to evaluate this situation. And this thing came to a head, and Mr. Weathers said, look, I just can't do this anymore.
Okay,
I mean,
well, let me-
this all is about the best.
Your
interest of
Honor,
children,
Your
Hold
Honor, and-
Hold
Your
on,
Honor.
sir, Mr. Owen, just hold on one
Okay.
second.
Yes, sir.
Ms. Shulman, go ahead.
hi, there's some inaccuracies in there, and I just, for the record, would like to correct them. I actually have met with the children at both parties' houses. I've gone to baseball games. What I said to Mr. Oldham was that if his client was asserting emotional abuse and severe abuse issues, there would need to be a forensic interview with a properly trained psychologist, and that a guardian ad litem does not do forensic abuse interviews with children.
That
The
would be
children
correct.
have-
If that's the
the
assertion.
children- And that's what I told Mr. Oldham in response to him, because he wanted me, and he's asked me on numerous occasions to essentially be the one who interviews the children in a forensic setting, and that's not something I'm qualified for. I do want the court to know also that the children do have a counselor, Ms. Bates, and they each have had, I think, approximately 6 sessions each. And since father has had them, they have had a disruption in their therapy. So I just wanted the court to know that I have made recommendations regarding some of these allegations, and I wanted to correct that on the record. Thank
All
you.
right.
Yeah,
Okay.
and Your Honor, all I was trying to point out is since this was very apparent on July the 6th, this was explained to everybody. We filed our motion. I've had 2 discussions with Ms. Schuman since then. I have offered her the opportunity to talk to these kids. I didn't ask her to forensically interview the kids.
Would
I
you
just
like
asked
it?
her
Would you like the court to appoint a forensic evaluator? Mr. Ullman,
to appoint a forensic evaluator for the children?
for the children.
I'd
If
be
that's
happy
your
to.
And
Your Honor.
Your Honor,
Wait a minute.
Your Honor, if I may
may-
on that issue,
may I
because
speak?
Mr. Oldham,
Hold
Well, I
on,
need to
Mr.
address
hold on,
that.
Mr. Ullman.
Your
Go
Honor,
ahead.
I'd
Hold
like.
on, Mr. Ullman. I'll let you finish. Hold on, Mr. Ullman. Go ahead,
Okay.
Mr. Go ahead. Go ahead,
Your
Matt.
Honor, back in May of 2023, so before July 6th, back in May, I had spoken to Mr. Oldham because he raised concerns of alleged emotional abuse by Ms. Weathers. And I want to be clear with the court that I actually I had emailed both attorneys at that point and let them know that I did not have evidence of any type of abuse from mom. But I did, at Mr. Oldham's request, I did reach out because there was a mental health shortage. And I reached out to Dr. Howard Drutman, and Dr. Drutman at that time said he had the availability to work with his family. I gave Mr. Oldham that information. I emailed Mr. Oldham and Dr. Drutman to connect them. Mr. Oldham at that time chose not to reach out to Dr. Drutman. And then recently, I think in the last week or so, I found out that Mr. Oldham reached out to a different psychologist, Dr. Bill Buchanan. And I've worked with Dr. Buchanan, but it's my understanding that Dr. Buchanan informed Mr. Oldham that the cost would be around $30,000. I think Dr. Drutman said his retainer, I can't remember now, maybe been 5 or 10,000. But I had gone back in May of 2023 and set up a forensic, because really what it is they're asking for a custody evaluator. And Dr. Drutman was ready and available. And I just wanted the court to understand that back in May, I supplied that information. Thank you.
Your Honor,
Mr.
all we're
Mr.
really
Oldham?
asking, yes, all we're really asking for is for an alcoholic, abusive mother to not.
Your
be-
Honor, objection, that is.
Okay, all right,
That's what she's
Mr.
done.
Mr. Ullman,
Yes,
that's
sir.
not proper. That's not
Okay,
proper.
Your Honor, I'm trying to,
Mr. Ullman, you're not,
Yes, sir.
that's not what we as lawyers do, okay? That's not, okay?
I-
You need, yeah, if you present, even if you had that in a presentation, there's a lot better way to kind of say that.
okay,
So,
Judge,
please.
all I'm trying to do here is it sounds like the court is inclined to just do whatever it's going to do without hearing anything. And
No,
that's the problem.
Mr.
That's the
Ullman,
problem.
let me,
Yes,
Mr.
sir.
Ullman,
Yes,
let
sir.
me just kind of just tell you where we are. I mean, and
Okay,
look, you all have filed these particular motions, all right? I've read your motions. I did read them, okay? The court has to decide whether or not it's going to issue anything ex parte or whether or not this does rise to a level of an emergency, okay? I'm
Yes.
telling you that based upon my assessment thus far and my limited discussions with the parties in this particular case, that yes, yes, these issues need to be fleshed out. It sounds like they do, but at this point, keeping the parties at status quo would mean return of the children. And then what I would do is if you want me to do so, sir, Mr. Ullman, I'll go ahead and, if you want Mr. Druckman to do this parental fitness evaluation, because it is true, Ms. Shulman cannot do that. And it sounds like with a lot of cases, $30,000 doesn't grow on trees. So if you want these assertions to be investigated and to be vetted and for them to be presented to the court, then I'll give you the opportunity to do that. But I'm going to put it on a schedule and have you do that by that particular point in time.
Right.
So,
so.
and then we can kind of take a look at whether or not those particular assertions, along with Ms. Shulman's final evaluation, would dictate the court's ruling at that point in time. I'll be able to make a full discussion, a full decision at that point in time. I don't think I'd be able to do that this time because it sounds like if there are allegations in your case or assertions of abuse, I'd want to go ahead and have those certainly looked at.
I know. So, Your Honor, just bear with me, please. If all this is based on that Mr. Weathers has made up these assertions. And
We don't know. We don't- we don't know.
No, Your Honor, I know, we don't know. So what the problem is that if these assertions are true, which we have evidence, but these assertions are true, we're ready to go forward with that evidence. If these assertions are true, then
But you need, you need a qualified person. in
Your
order
Honor, but
to
I know,
present those.
but all I'm saying is that if these assertions are true, then what Your Honor is doing without hearing any evidence is putting these kids in a terrible situation. The court is supposed to be doing what's in the best interest of the children.
Sure,
That's all- that's all-
I'm more
that's
than
all we're
familiar,
asking,
I'm more
Judge.
than familiar about that, but
I
the
know,
court also has to have the proper evaluation, because I'm not a forensic evaluator. And if there are allegations or assertions of abuse, then I certainly would want to know whether or not law enforcement were involved, whether or not there are other trained professionals that will give this court the opportunity to kind of vet those best interests of the child under 1993, the factors through A through Q. So
Your
I
Honor.
understand that,
Okay.
and I certainly want to do that, but I don't think that forcing the issue in this particular manner by not returning the children is the way to do it. So
Okay,
I-
but and Your Honor, please just let me be heard.
So I'm gonna set a date.
Your Honor, I
I'll
just
allow
want
you-
to, can I tell you one thing, please?
Yeah, okay, go ahead, sir.
Okay, you understand, I guess, from reviewing the pleadings that mom had law enforcement come to Longhorn Steakhouse to try to take these kids. What you don't know from reviewing the pleadings is that mom herself said these kids are scared of her. What you also don't
Objection, Your
know,
Honor.
Your Honor, wait a
Yeah,
minute.
he's
Your
trying,
Honor,
look.
This is,
Your Honor, listen, all I want to do is a chance to put on some evidence, Your Honor, that we can
And
do.
you'll have, and
this-
sir, and you'll have that. You'll
Your Honor,
have
but
that.
the- but in
The kids have to be
but-
abused until we
wait,
get to hear evidence.
Your Honor, but that's
Well,
what
I
the
want
problem-
I want the evaluation to be finished. You all.
But they're
so
gonna be
look,
stuck with her in an
look,
abusive situation,
here-
Your
yeah,
Honor,
well,
until then.
Okay, look, and
Honor,
until I
that's-
get,
that's all we're
I don't want to
doing.
make this very short. So can we go ahead and have a friend, when's the soonest we could get a forensic?
Your Honor,
evaluation?
wait,
Hold on, wait a
first of
second.
all.
Hold up.
Your Honor.
Yes,
So when I spoke with Dr. Drutman back in May, now we're in August, and what they are talking about, it's not just the parental fitness. They're actually talking about Mr. Oldham, and maybe he doesn't realize it, but what he's really saying is a full custodial evaluation.
yes.
And that can take up to, I don't know, can take up to 3 months to get completed. And the other issue is I just wanted to make sure that that both parties realize that, like, as the guardian, I'm not, part of why I didn't recommend it is because I know that somebody's gonna have to pay for it. So I'm not sure how that's gonna work either, but I can reach back out to Dr. Drutman and see if he's available. And because
Madam,
I
would
do
you be
think,
willing to do that right now? So I
Yeah,
can. go-
you-
so I
you're-
can.
I can.
Mr. Ullman, let me finish.
Okay, Judge.
Go ahead and do that, and if
Okay.
if you could do that, I'll pause you all, and then I can kind
Okay.
of make some decisions.
Judge,
Based
I'll
on-
reach out right now, Your Honor. Thank you.
let me say, Judge, that I have talked to Mr. Drutman. I've talked to Mr. Buchanan. Okay, all I'm requesting, Judge, is before you make this decision today, that you allow us to provide you with just a modicum of evidence. If you think after you see that evidence, and includes the reason that Ms. Schuman should not be serving as the guardian in this case, if you believe after you see the evidence that it is appropriate to return these kids to their mother, then you can make that decision. All we are asking.
Sir,
is
you've
that you
you've
give
asked
us-
me that, and you've indicated that very eloquently. At
But you're
this
not going to
point,
give us that opportunity. is
I'm
what it
not
sounds
going to
like,
provide you
Judge.
the opportunity right now, because equity involves you come with us with clean hands, and I don't find that if you don't return the children to be clean hands and you're forcing the
If
issue.
Judge,
Your
wait a
Honor,
minute, wait a
no,
minute,
no.
Judge.
So at
Judge,
this point in time,
no,
that's what I'm
Judge,
going to do. Mr.
Judge,
Oldham,
please,
Because you let
please.
me, no, I got to move on to something else.
I know, but the only question
I'll
I have,
talk with
Judge,
you all in
is,
just a minute. I'll talk with you all in just a minute, okay? But that's
okay,
what I
we'd
asked Ms. Showman
like
to
to
do.
be heard on this, Your Honor.
I like Ms. Showman to go ahead and do that, and
Okay, we'd like to be heard.
then I'll let you know what I wish to do after that, okay?
All right,
So if you could put yourselves on pause, I'll go ahead and
Okay.
get back with you in just a minute.
thank you.
Thank you. Okay, state of Georgia versus some cash and a Mercedes-Benz, a Jeep Cherokee, a Lamborghini, Glock firearm, some other firearms. Okay, all right. I'm looking for Miss Rude and Miss Luttrell and Mr. Rude. And let's see.
I'm here, Your Honor. Grant Rude on
Ms.
behalf of the
Eitzel,
state.
Mr. Aurora. I have
Aurora's here, Your Honor.
Mr. Redding.
Vivian Uchitel here for the claimant.
All right, Mr. Feinberg, Ms. Beta, and Mr. Steele. And
Morning, Your Honor.
morning, sir. Then we have Ms. Colson, Mr. McGuire, Mr. Stay, Wrinkles, Matten, and Carr from the Attorney General's office.
Correct, Your Honor. Good to see you. I'm Matt McGuire.
Good to
Also
see
have my partner, Jen Colson.
you. Okay. Oh, you're here for the next case. I'm sorry. I
Yes, sir.
apologize for that one. Okay, let me, this is just on the forfeiture issue. All right, so councils, did you all want to have the matter taken down? Or do you have a court reporter, or what's your pleasure on that?
Yes, Your Honor. We have a court reporter who's present. Her name is Wanda Noyes, if I'm saying it right.
Where is Miss Noyes?
I am here, Your Honor.
Oh, there you are. How do you pronounce your last name, madam?
Noise.
Noise, just
Right.
like the sound almost?
Yep.
Okay, all right, I just want to make sure, madam. Okay, all
Is
right.
it okay if I turn my camera off, Your Honor?
Madam, that is far more than acceptable, okay?
Okay,
All right,
thank you.
okay. All right, I'm gonna go ahead and gin up the case at this point in time. We're here in the matter of involving several pieces of personal property items, vehicles, and cash under the case number 2022 CV 367165. And I understand that a mandamus has been filed. Can I ask which party filed the mandamus?
Yes, Your Honor. We filed it on behalf of Raffaello and Company regarding 9 pieces of jewelry that we had challenged.
Okay, Mr. Aurora.
It was filed recently because we've been waiting on a hearing. We did not stay our portion of the ownership interest that we provided about a year ago. And so we just needed to be heard because our client is currently paying about $6,000 a month in interest with regards to the jewelry that was provided to Mr. Steele's client.
Okay, and I would just tell you as a general premise, I believe that property is subject to a criminal prosecution, which I believe that I'm handling at this point in time. Is that correct, Mr. Rude and Ms. Luttrell?
Yes, Your Honor. And Ms. Luttrell is no longer with our office, but yes.
Okay, so it's just you. Okay, all right. So, Mr. Aurora, I believe that there's a statute which says that I have to, or that the criminal portion of the case stays the civil forfeiture at this point. And that's what I've kind of done. I believe that there was a motion filed by the state to condemn this particular property, but since since it's the subject of a non-finished criminal action, I've stayed it.
I agree. I understand, Your Honor. The issue was we were the innocent owner defense. Like, for example, the government has turned back numerous leased vehicles to the proper company as far as that goes. We provided extremely detailed correspondence, invoices, things of that nature that show that this is ours and it's costing us quite a bit of money. And
But I think that therein lies the challenge in this particular property, because it is because there's a criminal case it's attached to.
right, I don't disagree with that. The problem is when you look at the pleadings, no one else has filed a sufficient claim aside from, hey, it's just mine with regards to any of this. We stayed it for discovery and no additional evidence was provided by any other party regarding ownership of this. We're not related in the criminal case whatsoever. We're just a jewelry store in New York that would loan jewelry to entertainers and athletes to wear if they chose to buy it, they can buy it. In this case, it didn't happen. And we were just trying to get our materials back since we are paying the wholesalers for the jewelry that we designed specifically for this individual. And there is a massive hardship for us. And that's why I filed it, Your Honor. I totally respect and understand that it's a criminal case going on, but there's no criminal party that has a valid ownership interest in this that's been filed properly. Mr. Rood, at the end of the criminal case, his first defense is going to be the other side didn't file a proper statutory claim to it as far as proof documentation. Just because it was seized from you, that's like a drug dealer having a bunch of money. They just don't get to say, hey, I had the money, so it's mine, and that's a sufficient claim. We have provided everything in writing, invoices, bank records and payments, things of that nature. And so we just want to get it back. And if any other party wants to make a claim, it's a civil matter that should be held. Otherwise, we're losing so far to date almost $100,000 in interest payments on $1 million+ worth of jewelry that was loaned out to Mr.
Okay.
Is it Mr. Williams? I think Mr. Young Thug Williams. And so that's why we were just asking for this, is just to have a hearing, and we carved out an exception after discovery in that order that Your Honor signed, saying that we could have an ownership interest hearing within 30 days of basically December 2022.
All right, Mr. Rood?
Yes, Your Honor. And Mr. Aurora actually consented last year in the stay order that he's referring to, and I'll just quote from it. It says, the civil forfeiture case will be stayed until the criminal case is resolved as to all criminal defendants. And that would include Mr. Williams, who did file an answer claiming all of the jewelry that Mr. Aurora is referencing. So our position as the plaintiff in this case is that there is an active stay entered by this court and consented to by Raffaello and Company claimant, and also Jeffrey Williams as a claimant, that the case is resolved, or sorry, that case is stayed, certainly as to disposition of the jewelry. You know, if Mr. Williams had not made a claim on the jewelry, we may be in a different position, but I think it would be imprudent at this point to somehow release the jewelry to Raffaello and Company, Mr. Aurora's client, without a adjudication on Mr. Williams's interest as well.
Okay.
And so, Your Honor, Mr. Rood is reading it, but the rest of it, as your order says, we carved out an exception with Ms. Luttrell, which before Mr. Rood was out there. The order that Your Honor signed in August of last year specifically says we have a right to an ownership hearing within 30 days of discovery expiring. The state had asked Mr. Williams.
Criminal discovery or the civil discovery?
The civil discovery, because we didn't stay indefinitely. What we said is that they wanted to get discovery so Mr. Williams's attorneys could provide any documentation showing any type of ownership in this. Nothing was provided in the 90-day discovery period that we'd agreed to. And that discovery order specifically said, once the 90 days expires, we could ask for a hearing and get a hearing within 30 days as to our ownership interest so we can get our items back. The government knows this. It's written in the order that we signed, and that's the only reason we consented to the extension of the 90 days discovery. As Your Honor knows the statute very well, discovery isn't required in these types of cases until all the parties agree. They wanted to give the chance to Mr. Williams to file anything subsequent to, aside from, this is just mine. Mr. Williams has nothing to lose here. If he gets convicted, he doesn't get the jewelry. If he proves ownership and gets the jewelry back, he's still in jail until the case is over. But we are losing substantial monies, and that's why Ms. Uchitel and I provided extreme documentation from when this was provided, when it was. We've got social media posts, all those kinds of things, saying that it's ours, and he hasn't paid for it. And so if there is a dispute between Mr. Seal's client and ourselves, that would be a civil matter that we could haggle out. You can order it released and we will hold it. Or we will put a cash bond up for it as far as that goes, in whatever amount you wish, so we don't continue to have hemorrhage losses financially.
Is that something that you have talked with Mr. Steele about? I mean, that's a potential. I mean, if you're saying that the second order effect is that you're paying interest, then is that something that the two of you could maybe discuss as a matter that you all can resolve?
Yes, Your Honor, we certainly can. And Mr. Steele and I have talked again this morning. We provided him with extreme detail of what each piece of jewelry costs. We even provided him proof that his client had paid $200,000 about a year ago towards the million and change that it's worth, but then he stopped paying. And before we could file a civil claim against him, which is what Ms. Uchitel was going to work on, he was arrested. And so now we've been on hold for about a year and a half with this jewelry. So what I'm asking is, I will work with Mr. Steele certainly, but in the alternative, I would ask the court to let us post a bond, get the jewelry back so we can minimize our losses and go from there. I think we will succeed, but waiting another potential year, as Your Honor said, it might take for this lengthy case that you're unfortunately in the middle of. It just doesn't do any justice if we're an innocent owner as far as that goes. The court has that authority to do this.
Mr. Steele, you were on the platform? I think I saw you earlier.
Your Honor, I'm driving, so I'm just on audio, if that's okay. I apologize. I'm coming to your honorable court right now.
Okay. Go ahead, sir.
Well, we would like to work it out with the state and Mr. Aurora. Mr. Aurora must not be reading your honorable court's consent order that you entered. It was in September 27, 2022. And Your Honor, you specifically stayed the forfeiture cases you said earlier. So for Mr. Aurora to say that somehow Mr. Williams had some burden on him already is just not fair. It's not what the court ordered. And what Mr. Aurora is talking about at this quote carve out is really, I don't know why he wanted it in here. It's really non-effective because it specifically says in your order, same order, Your Honor, that the court specifically as to Manny Aurora's client, it says the name, at the expiration of the discovery period, nobody entered discovery, Your Honor. Mr. Williams claimed the Fifth Amendment privilege, or at any other time before discovery period expires, but not prior to 30 days from the entry of this order, Manny Aurora's client may petition the court for a hearing on its claim to property it asserts ownership of, provided that said claim exists and was not resolved, and the court will set the matter for a hearing within 30 days. And this is what I'm stressing, Your Honor, solely on the issue of Manny Aurora's client's alleged ownership interest. Whether the property is subject to forfeiture will not be adjudicated at said hearing. And the reason for that is because Mr. Williams' hands are tied, because we can't answer, based upon my advice to him, any of these questions. So I don't know what Mr. Aurora is saying. It's his client's property. Mr. Williams filed a valid claim. Mr. Aurora is saying the claim is going to be dismissed by the state. That's nonsense. So we're just stuck. But to answer the court's question, this is a monetary issue. I don't know if the state will agree to release the property or release the money, but Mr. Williams will, in good faith, through me, negotiate with Mr. Aurora. Mr. Aurora and I have a long relationship, a very strong one. I just read his documents. He filed them previously. I just read his documents. Understand it. There's much more to it from what I understand, but I told him that we can exchange information.
Okay, gentlemen, how long do you think that you need to take in order for you to have these discussions?
We can do it today, Your Honor. It's just something we've been going on through. I don't want to harp on the order. You can read it for yourself and people can make accusations however they wish. But our whole point was discovery was supposed to be so parties provide anything else. We had already provided this a year ago, all our documentation. And so the idea for Ms. Luttrell was, let me see if Mr. Williams has anything more than it's just mine. I understand they have a Fifth Amendment privilege. I'm not sure how that helps or hurts how he got the jewelry, but it puts us in a real hole, Your Honor. And that's why my only reasonable alternative was to put up a bond.
Well, that might be
that.
And that might be the solution in the matter, unless the state's willing to release those particular pieces. Mr. Rude, what is the state's position on that?
We're not necessarily opposed to that. I think it depends on any sort of resolution between Mr. Aurora and Mr. Steele in terms of their competing ownership interests, because it essentially comes down to Raffaello and Company is claiming the same jewelry that Jeffrey Williams is claiming.
Yeah, okay. How about if I were to give you 30 days? Would that be enough? And I'll put you back on and let's see if we can't you all can't come up with a solution, and if you're not able to come up with a solution, of course, I'll hear it, but, or I'll carve out enough time to hear it, but, would that
Your Honor,
work?
can we do it 14 days? I don't think that we have that much time. I provided all the documents again to Mr. Steele as he stated. I'm happy to listen to anything that he's had. And we even offered him, his client paid $200,000 for his $1 million plus. We would give him back his entire $200,000 just to get the jewelry. We've already offered that. But the sooner the better, Your Honor. I don't think we need 30 days, maybe a week, 2 weeks. The earlier the better, because we're losing money otherwise.
Your Honor, can I say something?
You certainly can, sir.
Your Honor, 30 days would be requested. There's evidence that Mr. Williams, there's documents, there's correspondence, Mr. Williams has paid $700,000. It's not as clean as Mr. Aurora is making it. There's also money exchanged, US currency. So listen, I don't know. I wasn't involved, but we are trying to get to the truth of it. But as the court knows, we're in the middle of jury selection. Mr. Williams is in custody. I have to deal with his business managers. They're in California, and his money managers. I can't do this within a week or 2 weeks. Mr. Aurora doesn't understand our position, which I respect, but 30 days would be requested.
Mr. Aurora, I understand your position, but, and I certainly am not giving it due consideration, but I think Mr. Steele raises a valid point. So, and then we've got some other things going on with, the court does on other unrelated business. So, let me see what I can give you around that time. Mr.
Okay.
Kearns, what do we have, sir? You have to unmute yourself, I think.
That's right, Judge. Thank you. I just talking away over here. We have the week of September 11th. We have the 12th or the 14th now.
Let's do the 12th, sir, and let's put them on by themselves so that if we do need to have a hearing, we can, they'll be the only thing that we hear.
Absolutely, Judge.
And Your Honor, maybe we do that in person because there's going to be a lot of documents if we're actually litigating it. And I don't trust the screen sharing back and forth if that's acceptable to the court.
Yeah, we can do it in my courtroom, 8F. That's
Yes,
fine.
Your Honor. Okay. Will Your Honor be sending out a notice then for the 12th?
Yes, sir. We certainly will.
Okay. Well, thank you for your time this morning.
It'll be September the 12th at 8:30, courtroom 8F. Counsels, does that work for you all, Mr. Steele? Man, I should probably ask Ms. Resnick Steele if that works for you. Okay. Does that work, madam?
That's fine, Your Honor.
Okay, all right. With the CFO as CEO said that's okay for you. All right. Let's do councils, any other unrelated issues, but yeah, that should be the fine. And if you all work it out between then and there, we'll mark you off the calendar and nobody will be the wiser. Okay.
Yes, Your Honor. Thank you.
Thank you, Your Honor.
Okay,
Thank
so
you, Your Honor.
September 12th, 8:30. We'll see you all then. And if you file anything, please, if you could copy Mr. Kearns so I can have it and look at it. And we'll go ahead and visit with you all accordingly on that day if necessary, right?
Yes, Your Honor.
Thank you for your patience, everyone.
Thank you.
Thank you, Your Honor.
All right, be well.
Your Honor, this is Eileen Schuman.
Madam.
Hi. So I did call Dr. Drutman and my phone was on Do Not Disturb because we were in court. So he called me back. We missed calls. I sent him an email. And I think what I can say to the court with certainty is that two things. I just want
Are the
to.
other parties back with us?
Oh, I'm sorry. You know what?
They're not back
No.
yet. Okay, hold
Here
on.
they are. I
Judge-
see them.
Judge, we're here.
Okay.
Okay.
Hey.
So, Your
Go
Honor,
ahead.
what I can say to the court is that I've reached out to Dr. Drutman and I can, if the court's going to do this, I mean, I can call a couple of different psychologists. I can present the court with an order for the court's consideration on this issue. And then the only other thing that I would just mention to the court is that, you know, the children do have therapy appointments coming, like set up for, I don't have the exact dates, but they're set up for the first available that they were. So I would ask the court also just to, you know, make sure, or if it's okay, in a custody evaluation order, I'd like to make sure that it's clear that these children should continue their therapy with Ms. Bates, because I think that that would be helpful, you know, based on what's going on.
Judge,
Do we do it? So let me
Yeah.
kind of see before I
Yeah.
let Mr. Ullman respond. Do we have, is Dr. Drutman available?
I'm not sure because he may be in a session, and that's what I'm saying is that I can't, you know, I can't speak for him. I can, if Dr. Drutman is not available, I can reach out to some other people, but I'm just saying I don't have a good answer right now, and I didn't know
Okay.
how long the court would want us to wait on that issue. And
Because-
I just wanted to make, I just wanted to make sure that, you know, the kids, that it's clear that my recommendation has been and continues to be that these children continue their therapy with Ms. Bates. You know, and I had filed a motion because the kids, just so the court understands, the kids have not been in school. School started on Monday and it's now Thursday, and the kids missed Monday, Tuesday, and Wednesday.
Yeah, I'm, like I said, but the biggest thing for me is I need to kind of set you all a backstop date to make sure that the initial, whoever it is going to do the evaluation
Yeah.
that is in a position to do so. And,
Judge,
Right. And Your
Judge,
Honor, I can, I'll reach out
I
to
may,
Dr.
Judge,
Drutman.
maybe
Sir, Mr. Ullman, do not
Yes.
interrupt me again.
Okay, thanks, Judge.
I told you as soon as I'm done, that's just rude. As soon as I'm done, I'll give you the opportunity to fully vet your position. But you have interrupted me like half a dozen times. And I just find that to be totally insensitive, rude, and unprofessional.
Fair enough.
So Your Honor, I'll reach out to Dr. Drutman. I can reach out to a couple of other psychologists, and I don't want to get into the merits of anything, but the other problem with this case is that Mr. Oldham has been spending time with the children. So I just would like for the kids to be able to continue their therapy, and I would like to be able to, in the order that I present, I'd like to say that, you know, neither party's attorneys should be meeting with the kids or speaking with them.
Okay.
And that's really my request as the guardian. And I know that that Mr. Oldham reached out to Dr. Buchanan, and I have a fine professional relationship with him. But based on the fact that Mr. Oldham recently disclosed that he has met with the kids a few times, I just have to find out if what Dr. Buchanan, I don't even know if he's seen the kids. I don't know what's going on. So I'm trying to find somebody who has not been involved with this family and who is like an actual neutral evaluator. And
Madam,
I will check with Dr. Buchanan's office because I do believe him to be professional and ethical.
Madam, let me ask something. How are the parties paying your, because this particular issue is going to cost, and I need to kind of figure out who's going to what the parties are going to or should be their pro rata share at this point in time. So what's their current arrangement with you?
I've been paid, I think, $2,000 total. And there's an outstanding bill of $1,700 that has not been paid. And I think the order was supposed to just be a 50-50 allotment.
Okay.
But because of the seriousness of Mr. Weathers' allegations, you know, I fully support there being an actual professional to do a custody evaluation and to be able to do, you know, the full testing. I want the court to also know that Dr. McGarrett early on in the case and Dr. Anton is a substance abuse evaluator. He had done some testing. Dr. McGarrett did strictly psychological testing. So whoever the custody evaluator is would be able to review those, and maybe that would help with some of the costs. I don't know. Those tests are old now, so they may have to redo them, but I wanted the court to understand that there's kind of been bits and pieces. So that's really up to the lawyers to explain their clients' financial positions.
Your Honor,
But for the court to
Hold on,
understand, that's
Mr.
it.
Lewis, hold on.
Yes, sir.
That's
Let-
it. I mean, I just wanted the court to understand, I've been paid $2,000.
let
I've been in
me,
this case since 2021.
okay. Councils, let me kind of ask you to begin with, and Mr. Ullman, I'll let you start to begin with. I want to know what your current financial division on these extra, on the payment of the guardian ad litem, because I'm trying to find out how or what's the best way to allocate it. So go ahead.
Is that me, Your Honor?
Yes, sir.
Oh, okay. First of all, Your Honor, this thing has gotten way sideways, okay? And what I would like to do, if we could, because there's a lot to unpack here, could you finish with the calendar? And could we talk about this? Because I have actually talked.
No,
to
sir.
Judge.
Sir, I have other business I have to,
No,
I'm butting up against at 10 o'clock.
Judge, I get it, but I mean, I actually have talked to Mr. Drutman, to Dr. Drutman. Okay, Ms. Schuman, when she made it clear that I had an obligation to do that, the way this all came up to begin with was I was telling Ms. Schuman about some of the allegations. I didn't realize at the time that Mr. Weathers had been making these for more than a year, and Ms. Schuman knew about that. Ms. Schuman told me that I would have to use Dr. Drutman. I said, and that I needed to talk to him because it was going to be costly and it could also take a good bit of time. And I said, I'll talk to the client and we'll decide if we want this custody evaluation. So that's what's happened. I then start understanding more about this. And so I'm not even asking for a custody evaluation. We could actually go, Ms. Schuman, I say she hadn't done her job. She says she has. I'm happy to attack her recommendations based on what she hasn't done. So we don't need, what we really need is finality in this matter. It needs to be set down for a final hearing. These parties have been working off of a temporary order that was in effect before a 30-day-old child died in her mother's care, okay, suffocated in her mother's care. That was a temporary order that was in effect before this happened. Dad has been stuck with this temporary order ever since. Ms. Schuman got in the case and immediately recommended, in a situation where a father and mother lost a 30-day-old daughter and two little boys lost a sister, that it was best for these children to be with their mother for most of the time, okay, and have hardly any contact with their dad. That has continued, and we're not talking about a deadbeat dad. We're not talking about a drug dad. We're talking about a great dad that loves these kids. He attends every one of their games. He's been ostracized from being able to coach for them. There are a lot of things going on here, Judge. We're not just making this up, and we're not taking this lightly. And so all we're asking you to do before you put these children back in that situation, and I can prove this stuff, is just give us the opportunity to present that to you before you make this decision today.
For the
If
third.
yes, sir.
Right, I'm sorry. No, go ahead.
No, well, it sounded like you were getting ready to tell me none of this matters.
No, sir,
You're going to say,
you're putting words into my mouth, okay?
okay, I'm not trying to do that, Judge. I'm just trying to, look, Miss
Sir,
Schuman.
look, sir,
Judge,
sir,
please.
you're being an advocate. I understand that. I don't have any issue with that. I
Okay.
really don't. But I'm telling you that everyone's equities are important, but we
Agreed.
need time to kind of unpack that and make sure we get all of the relevant information in front of the fact finder, me, so I can make a decision that's in the best interest of the child. But what I'm going to tell you what I won't do is I won't go ahead and rush this decision because one party has decided for whatever reason that they think they're right and that they're going to go ahead and withhold the children. So
Okay.
we're not going to do that. So I have, at the end of the day, sir, you've asked me 3 times to go against that. I'm telling you, I'm not going to do that.
Right.
So I'm telling you, I'm going to order a full custodial evaluation based upon some of the things you've said to me and my experiences doing this particular type of matter. Lead the court, that is, in the best interest of the child, to determine that a custodial evaluator, especially since the guardian ad litem has said that might be an appropriate other piece of the pie, because she is not the person that can make those determinations. I think that is appropriate under the circumstances. So It's not that I'm not going to hear your matter, Mr. Ullman. I'm not going to hear it in the way and manner you want it today.
Right.
And I want you to return those children back to the mother. I want you to start them back and facilitate their being started in school. I want them to go to their particular therapy evaluations. And in 2 weeks hence, I'm gonna make sure that a custody evaluator is in fact appointed, because I'm gonna give you a date certain right now that I want that to occur. And then on that date, all of you are gonna come back and I'm gonna talk with the custody evaluator, and the custody evaluator is gonna tell me, hey, Judge, I've met with the parties, they're, fine folks. It's gonna take me X number of times to do this. And I'm gonna set you a schedule based upon what he or she tells me that is gonna keep close hold on this particular issue. So that's the best I can do you at this point in time, Mr. Ullman, and I think that's the most prudent and proper course of action. Okay?
May I speak?
All right, so I'm gonna get that date right now.
Judge,
Hold
may I
on,
speak?
Mr.
May I
Kearns?
speak? Okay.
Mr.
May I
Kearns, go
speak?
ahead and get that, and then I'll let Mr. Ullman speak. Go ahead and get that date for me, please, sir. 2 weeks.
How far out, Judge?
2 weeks, please.
2 weeks?
Yes. Now, Mr. Ullman, as you were saying, what were you gonna tell me?
Yes,
While Mr. Kearns is looking for that date?
Judge, as you heard Ms. Schuman say, the seriousness of these allegations. So they're serious allegations, and all we are talking about is we're talking about you're going to put the kids back in the situation where there's serious allegations.
I don't know that, sir. I really don't know.
But Judge,
I don't know that, but you taking the children on your own accord, one-sided, is not what we're going to do. Okay.
Judge, if these were your children and they were in that situation,
that's
you
improper.
couldn't,
That's
I'm just
improper.
saying you couldn't in
Sir,
good
that's
conscience
improper.
put them back in that situation. That's all we're
Sir,
talking
that's
about.
improper. You have made you and your client have made a unilateral decision based upon, I don't know what, but
Good faith.
you are not the proper parties to make that particular call. The proper
Judge.
party to make that call is a custody evaluator. And as Ms. Shulman, if I believe any monicum of what she says in this particular case, if she's offered you that particular circumstance, you would have jumped on that early in this case, February, March,
Judge,
April, or May.
That's what I'm saying. You're taking everything at face value. I'm trying to explain to you that what you've been told, I can demonstrate it.
Well,
It's
no,
not
I
true.
want those.
It's
other
not
pieces.
true, Judge.
I want those
I-
other pieces of
Judge,
the puzzle to
I-
make the best decision that I can.
That's
So-
fair, but Judge, all I'm telling you is that you've not been told the truth here.
Well, you know what? If
Court.
I haven't been
Judge,
told the truth, there are ethical bodies in Georgia that will subject lawyers to not doing what they should be.
Judge, we're talking about the best interest of the kids. Okay,
And
so
I am too.
Judge, please let me ask you this, and then I'll shut up because I know I'm not going to be able to be heard. Okay.
Yes, sir. You're not going to be able to be heard on your emergency today.
No,
It's
I
not
didn't-
that you're,
Judge,
it's
I
not that you're
didn't-
not going to be able to be heard.
Judge,
So,
I didn't
sir, I
make-
take this very seriously, but I've told you the reasons why. I think they're reasonable in the circumstances,
Judge.
and that's what I'm going to do.
All right, may I be heard? I didn't file this as an emergency motion, Judge. Here's all we're asking you to do. Okay, so you're now appointing a custody evaluator.
Correct.
That's fine. Okay. The only question that I have for you, and this is when I filed the motion to maintain the status quo. These kids have been doing great with their dad. The only reason that
But
they're
you
not-
switched that.
Wait a minute. The only reason that they're not in school this week is because we said, hey, look, we're going to have a hearing before the court. This is important enough where dad was taking a chance on being held in contempt, going to jail. Okay, so this is important. This isn't just some minor matter. So all we had asked coming into this was, why don't y'all just agree, whether you agree with what dad's doing or not, just allow him to maintain the status quo so we don't have to worry about mom trying to snatch the kids at Longhorn. We know she already had planned to snatch them at the school. Okay, we just wanted to let Your Honor know, look, this is serious business. And because it's serious business and because you have an 11-year-old and a 6-year-old that are involved, it should matter. So what is the big deal? You're now set this out for 2 weeks. Why not just maintain the status quo for the 2 weeks? That's
Because
all
that's
we're
what I
asking
decided
for.
to do based upon what the circumstances dictate. So you may disagree with me, Mr. Ullman, professionally, but that's like I said, been doing
I
this.
just want a chance to present evidence, Judge. You won't let me
And
do
you,
that.
and you, no, I
You will
won't let
not- you will
I
not
won't
let me do that,
do
Judge.
I don't think it's proper today.
I know, but you won't let me do that, but then
And
you're gonna put these kids
and
in
I
a
think that
serious,
you have,
serious
I-
allegations, and you're gonna put the kids in that situation. and
sir,
you
you know, sir,
present the
no judge,
information
no
today.
judge worth their salt and no party worth their salt is gonna do that. But you know what? Also, we don't take the children, force the issue, and then say we're righteous.
Judge, we didn't do.
And
listen,
if that's the case, well, then I certainly have a lot of, I'll have a lot of explain, a lot of explaining or otherwise taking responsibility for that. Because I
Well-
certainly want to make sure that under 19.9.3 and its various subparts from A to Q, that that I get this correctly. But I want to make sure that we have all the pieces for me to make that particular decision.
Judge-
So we're not going to
Judge-
have that today, but I'm going to get everything in place for me. to go-
Understood. Judge, are you aware? I think you
Sir,
are. but
sir,
Judge-
let's stop.
Judge,
Let's stop. You have made the same arguments
No, I
at
haven't.
least-
This,
at least 5 times now.
this is about the defects protective order, Judge, that was entered in this case to begin with, that you signed, Judge. You
Objection,
signed.
Your Honor, we're now going back to April 2021.
Yeah,
Your Honor has heard this case so many times since then. Judge Newkirk has had, I think we had 3 or 4 hearings in front of Judge Newkirk. Nothing was ever modified, Judge, for a reason. And Ms. Schuman has been doing an excellent job investigating everything in this, and there's a reason why nothing has been modified. And we are here, as Your Honor said, because Mr. Weathers decided to take this all into his own hands.
Mr. Kearns, what do you have for me a couple weeks hence?
Judge, we have, we can set it for the 24th
Of
of August. Mhm,
Okay,
Thursday
what
the
time?
24th. We could do 8:30 a.m.
all right, let's do 24 August at 8:30 a.m. And parties, what I would ask you to do is work with your lawyers and the guardian to go ahead and get, at least meet with whoever it is that you have, that we're gonna hire as the custody evaluator. Ms. Showman, if you'll send me over an appropriate order, I'm just gonna allocate 50-50 with a reallocation provision, please, madam.
Judge, may I ask you one question? Not going to argue. I'm just asking you a question. So the parenting time schedule is, I believe this is Mr. Weathers's weekend. I know he's had the kids in violation of the order because nobody will hear what we have to say, but I get that. So do you want to go back onto is your order that we go back onto the existing schedule under the consent temporary order?
Yes, sir.
And
Yes,
would your, okay, so he would have them through this weekend. And would your honor, these kids have been begging to see their dad, the dad's been begging to see the kids. We filed for a modification. Would your honor entertain giving a week on for each one of the parents until we?
Not
get
at this
through with
time,
this?
sir.
Okay, but would you entertain that on August the 24th?
No, sir. And unless you all agree to that.
Well, they're not going to agree to it. I know
Through
that.
agreement, or the custody evaluator or Ms. Showman recommends that to me. And I think that would be by concurrence of you all. So, you know, part of co-parenting is you're all going to have to talk. So this may be an exercise in you all being able to do that. Or having.
Well, Judge, we've tried that as well. It doesn't work because mom has used these kids as
Your
pawns
Honor,
in a game.
Your Honor,
That's what's happened.
I
got the evidence, Judge. I've got the evidence, but nobody wants to hear it.
Your Honor, we have been myself as well as Ms. Schuman have been asking for this evidence for over a month now. We still haven't seen a single shred of anything. Your Honor, the only thing that I'm going to say is that Mr. Weathers has had these children from his own unilateral decision for over a month now. I would ask that if we're going back to the plan that's in the consent temporary order that Ms. Weathers had this weekend.
I thought about that, Mr. Lewis. Let me just kind of, the easiest thing for me to do at this point in time, because you all won't agree upon this, is to just go ahead and reinstitute the schedule with the understanding I can modify it based upon what I hear later to potentially make up those days. Okay.
Well, and Your Honor, it's written in the consent temporary order that it's just every other weekend. So I'm not sure how they would have come up with that. This is what that was supposed to be. That it was supposed to be his anyway. And
whose weekend would it have been Whose weekend would it have been had the order been followed to the letter?
We believe it would be Mr. Weathers' weekend, Your Honor. He gets so little time with these kids that he knows when he should have them.
Your Honor, he's had them for over a month now. Straight.
Wow, why would it matter? He's a great dad.
Well, here's the
Why are you
thing.
trying
Let
to
me-
keep
let
these
me-
kids
let
from
me-
their dad? It
let me-
doesn't
let
make
me-
any
let- let me-
sense.
Let me just kind of, Mr. Lewis, I understand what you're talking about. Let me just go ahead and reinstate the order because I don't want to judge whether or not it's improper, or whatever. I can do that later. And then I can reallocate the time based upon that,
Yes, sir.
that ruling. Okay? All right. Ms.
Your
Showman,
Honor,
yes, ma'am.
one last question. And so is it okay and permissible for me to put that there be no contact between the children and their respective attorneys in
Yes,
the proposed order?
yes,
And that the children will continue therapy with Ms. Bates?
yes.
Okay, thank you.
Hey, Your Honor, and just for the record, so that there's nothing untoward going on here, I actually met with these children because they were traumatized with what happened to them for over an hour at the Longhorns restaurant, where they were trapped in a booth with their father, with the police, and with the mother and her brother-in-law hovering around the booth trying to get these kids out of a Longhorn restaurant. I came and met with those children just to make sure that they were okay. I didn't talk to them about this case. I've not questioned them about anything. I understand my duties as an officer of the court. I am the one that's here trying to do what's in the best interest of these children. I want to make that crystal clear.
That's
Okay?
fine.
And the rest of it will come out through the evidence. If this is the way we got to do it, then this is the way we got to do it. We would
Yes, sir.
appreciate the opportunity to be heard, but that's not going to happen until August the 24th, it would appear.
Yeah, well, yeah, we're gonna get it on the path of, for the court to make a decision in the best interest of the children. Yes, sir. And I will on the 24th, meet with you all and kind of get this path, help you all continue along the path at this point. All
Your
right,
Honor,
folks.
Final question. Are we actually, is it going to be more than just a status conference, or can we come be in your presence and can we actually go through sort of where we are and
No,
where we need to go from
sir,
here?
sir, we
Yes.
can go through where we are, okay,
Yes,
but
sir.
with the guardian and the custody evaluator.
Okay.
Goal on that day, the goal on that day is basically overarching scheduling and getting down to the brass tacks of how long it's going to take in order for that to finish, because you all need those pieces in order for you to make some decisions on behalf of your clients. And then Ms. Showman needs that in order to make the best evaluation that she can make to me. And I can kind of also put you on a glide path for resolution, because then you'll know, hey, that we are in fact going to resolve this matter in this particular time period. So you'll have that to look at.
Okay.
So that's what we're going to do on the 24th. And then I'll be available, of course. And then I'll set a time for that based upon what the custody evaluator tells me to either do a status or to maybe do some other see where you all are in terms of potential hearing on final resolution.
Judge,
Okay?
I want to be clear. You understand there are no allegations of unfitness of Mr. Weathers as a father. We're getting a custody evaluator now being appointed when you have parents who are perfectly capable of making appropriate decisions for their children. So
Yes, sir.
I understand that's what you're going to do. I don't mind the kids. You know, the kids hopefully will have somebody to talk to, but this is the state stepping in to make decisions for a perfectly fit father.
Your Honor, we would certainly disagree with that, as I don't think any perfectly fit father would withhold their children from over a month from the other parent when that's in direct violation of a court order. Your Honor, just one more thing as to what Mr. Oldham was saying as to his direct contact with the minor children. Judge, he flat told law enforcement that he's heard these allegations directly from the children. Judge, and that's the basis of our motion to disqualify Mr. Oldham, which I would ask that be heard either today or on the 24th when we come back, because he has explained to myself and Ms. Schuman that he has spent a significant amount of time with these minor children, which I can't think of any capacity and where any professional should be doing that especially when there's a guardian ad litem appointed in the case.
Let me,
Your
okay,
Hey, I
let me say this, Mr.
Yes.
Lewis and Mr. Ullman.
Yes.
Let me go ahead and reserve that to the 24th, and I'll make a decision on setting a hearing date at that point.
Your Honor, what I'd like to do is I will respond. I mean, you can expedite the hearing on that if you'd like to. I will respond to this motion. I didn't say I heard anything directly from the kids. I've heard a recording from the kids that they've been punished. Okay, that's all that it is. This is nothing more than that. So they're going to try to disqualify me apparently for being a witness, which I'm not a necessary witness. I'm not going to be a witness. Then this is all more of the same games we've been dealing with, Your Honor. Then apparently in some other states, I would have committed some ethical violation, according to Mr. Lewis. Well, file the bar complaint is all I can say. This is totally absurd what we've been dealing with. I can prove all that, Your Honor. I just hate
Okay,
that you
well,
put
like I
these
said,
kids back in that situation.
I'm not going to take it up today.
Okay.
I'm gonna give you an opportunity to respond. I'm gonna, on the 24th, when I talk to the evaluator, Ms. Showman, and you all, I'll then decide whether or not, and if and whether or not, if and when I need to hear it, I should say. Okay, and I'll set you a date certain at that time. All right.
Okay. Would there be any possibility to present evidence at that time, Judge?
No,
Or
sir.
it's gonna
No,
be-
sir.
okay. She
No,
wouldn't
sir,
do
not at that time.
Okay.
Okay. I
All
mean,
right.
like I said, we'll get there, but just not that. Just give me a little bit of time. Okay.
All right. Thanks,
All right.
Judge.
Thank you, sir, and ladies. I'll go ahead and see you all on the 24th at 8:30, and via Zoom. We'll talk then. Okay.
Okay. Hey,
Your
Judge,
Honor.
could that be in person or it's just going to be Zoom?
It'll be Zoom, sir.
All right. Thanks,
Your
Judge.
Honor,
Thank you, sir.
would you like me to prepare an order?
Yes, and you can
for the
send that
rulings
to,
today?
yeah. Yes, I would, Mr. Lewis. Between you and Ms. Showman, I like the appropriate order. Make sure you send that to Mr. Ullman.
Yes, sir.
That would be
course.
appropriate.
Yes,
Okay.
sir.
All right.
May we be.
Thanks, Judge.
Yes, y'all may be excused. Be well.
All
Thank
right.
you, sir.
Okay. All right, let's see. I have Salmon Cape Production versus the Georgia Department of Economic Development.
Morning, Your Honor. Matt McGuire and Jen Colson for the petitioner. This is an APA appeal.
All right, do you have a court reporter?
We do have a court reporter. Her name is Tanja Donnelly. She's up on the screen.
All right, Ms. Donnelly,
Good
can I
morning.
get you to hold on one second? Let me go ahead and take up just one other thing. Ms. Bashir,
Absolutely.
good morning, madam. Ms. Bashir, can you unmute yourself, please?
Yes.
Madam, I called your case a little bit closer to the beginning of the calendar. And I don't believe you were present, and we didn't start until probably about close to 9 o'clock.
I know I've been on ever since about 8 o'clock. So
Yeah, and I apologize to you because we've had some technical and weather challenges, but we didn't cover anything. And I just reset it for the 14th to the 14th of September at 8:30.
14th of September.
Yes, ma'am, at 8:30. And
Okay.
you'll get another notice, and and I would invite you, since you're representing yourself, talk to Mr. Chambers before. I invite you to talk to Mr. Chambers before then, okay?
I've talked to Mr. Chambers. Mr. Chambers has, we've been back and forth. And Mr. Chambers, I told him that I was willing to let the housework go, what I have, the work I have had done in the house. I was just asking for the mortgage I had paid in the house and the taxes and the insurance that I continue to pay right now. And I also didn't pay any taxes for last year, nor have I paid the taxes for this year because they split up the house.
Okay, well, just talk to him, and maybe y'all can work out something. And if you work out something, you don't need to appear on the 14th, but okay.
I've been trying to work out something with him, and also, Judge, Your Honor, I've been in this house 25 years.
Okay, but I can't, madam, I can't hear the case right now. Okay,
I
so-
know,
so
okay,
please don't share any other information with me. I know you want to, but don't do that, because I'm just a referee and nobody else is here on the other side. Okay.
yes, sir.
Okay. All right, madam. Well, I'll talk with you all on the 14th of September if that's necessary. Okay.
And it's at 8:30 again?
Yes, ma'am. And you'll get a notice. Okay.
Okay, thank you so much,
All right,
Judge.
Thank you. Be well. Okay.
Bye-bye.
Thank you. Bye-bye. Okay, Ms. Donnelly, I think I'm ready now. Okay.
Yes, Judge.
Okay, all right. Good morning, council's interested parties. We're here on the record in the matter of Sam and Kate Production LLC versus the Georgia Department of Economic Development in 2023 CV 379042. We're here on a petition for judicial review. Can I get the parties to identify themselves for purpose of the record? We'll start out with the petitioner.
Sure, Your Honor. Matt McGuire and Jen Colson for the petitioner. And also we have our client on the screen. His name is Adam Beasley. He's an executive producer.
Okay, and for the respondents?
Your Honor, good morning. For the respondents, Ron Stay and Savannah Mateen from the Attorney General's office. Also present is Sarah Gershon from the Georgia Department of Economic Development.
All right, good morning, councils and parties. Okay, so petition for judicial review. And I did get the record that was forwarded to me, so thank you. And so at this point in time, I'll entertain argument. You can have up to 15 minutes if necessary. And then I'll hopefully be able to make a decision in this particular case. I've heard scores of these. I'm usually familiar with the issues. I tell the parties up front, and there are very limited circumstances that I can usually override a decision of an administrative body. They're set out in statute, and most of the time, if there is, you may disagree with what they've done, but if there's any evidence in the record to support that agency's decision, I have to follow it unless they have been arbitrary and capricious, failed to apply the applicable statute. And I want to say there's about 2 or 3 other bases, but usually those are usually the things that I can consider. So with that, we can go ahead and get started, and you all having the matter taken down. I'm sure you're going to share and take down. Is that correct?
That's correct, Your Honor.
All right, go ahead.
Your Honor, may I share my screen? I've prepared a PowerPoint.
Remember, you only got 15 minutes. Okay, so
I know, I'm gonna work quick.
So get with it. Yes, you can share your screen.
Okay, it says it's disabled. The host.
Hold on, let me see if I can. I know a guy. All right, so Mr. Kearns, can you enable that for me, please?
It should be enabled now, Judge.
Right.
Excuse me.
Go ahead, Mr. McGuire.
Okay, let's see if I can get that to work. Okay, so Your Honor, we appreciate this time. This is a denial. This is an appeal from a denial of a Georgia film tax credit by the Georgia Department of Economic Development. And there were actually 3 applications that were submitted. The first 2 were rejected as being incomplete. And then the third one was denied as being untimely. And we are appealing, we are alleging error on the basis of all 3 of those decisions by the department. The standard of review, you actually articulated it pretty well. We are alleging that the decisions were clearly erroneous and arbitrary and capricious, and that they violated substantial rights of my client. There are 2 rules that are going to be implicated in this hearing. The first one is that the application, at the time that the application is submitted, the project must be fully funded. And then the next rule is, and these are economic development rules, the next rule is that the application must be submitted before principal photography ends. So what do those terms mean? Fully funded is somewhat of a misnomer. It means that the project has 75% of the assets that are needed to cover the budgeted costs. And then principal photography means the principal shooting involving the stars of the show, which is intended to be incorporated into the final product. So doing credits and outtakes and things like that are not principal photography. So to walk you through the facts as quickly as I can, first application was filed on February 9 of 2022. As of that time, initially there were to be 22 days of principal photography. The lender for Sam and Kate told them that they needed to hold back additional funds for contingencies. So Sam and Kate reduced the schedule down to 20 days. They did that before they submitted the first application. They submit their application. It says that the principal photography end date is going to be March 25, 2022. Says that there are going to be 20 days of principal photography. Miss Allison Fibbin of the Department of Economic Development emailed them that very same day and said, your application is rejected. The commitment letter, which was the funding evidence, was unsigned. So they go back and they submit a second application on March 4th. Very similar application, it has very similar commitment letter, although this time it's signed. 20 days of principal photography, end date of March 25. At that point in time, Ms. Flibbin says that she is rejecting the application because the commitment letter from the lender, although it was signed, now she claims that it is not binding on the lender. So she says that there are no applications, that no decision is going to be taken on the application. So then on April 8th, they submit their third application. Now, after the second denial, Your Honor, my client wasn't taking any chances with the funding, so they actually submitted with a third application a signed loan and security agreement from the lender. And it's undisputed that that met the fully funded requirement under the rules. So they had corrected the only deficiency that had been noted in the application. And at this point in time, they had added back in the 2 days that they had to cut from principal photography because they were much more confident that their application was going to be approved. So the third application had 22 days of principal photography, and the end date for principal photography was going to be April 15th of 2022. Ms. Fibbin rejected that application as being untimely. So notwithstanding the fact that the application said principal photography was going to end on April 15th, she decided unilaterally that it actually had ended on March 25th. And what she did was somewhat remarkable. We learned in the hearing for the first time, she contacted the Screen Actors Guild and spoke with someone there. We don't know who that person is, but somebody at the Screen Actors Guild apparently told her that principal photography had not been extended for the Sam and Kate film. Now, there's not a scrap of evidence, no documentation of that call. There's nothing in the file. So Ms. Fibbin denies the third application, claiming that it is untimely based on that hearsay conversation with SAG, and also based on supposedly the earlier principal photography dates from the first two applications. So I'm going to take up the first enumeration of error, which is that the third application was untimely as determined by the ALJ. It's a little bit involved. I will go as quickly as I can. Sam and Kate in the hearing, of course, objected to the SAG statement as being hearsay. Judge Boggs allowed the statement to come in, not for its truth, but only to explain Ms. Fibbin's conduct, in other words, her denial. In fact, Judge Boggs criticized Ms. Fibbin for basing the denial on the SAG hearsay and on the two earlier applications. But she found that the department had cured that procedural error during an internal appeals process when they allowed Sam and Kate to provide additional evidence on the principal photography date and supposedly denied the appeal based on that additional evidence. Now, Sam and Kate submitted at the invitation of the department a call sheet for the crew that was dated March 25, which was, as you'll recall, that was the earlier principal photography wrap date. And it said that that was day 20 out of 22. Also, they submitted the affidavit from an executive producer named Michael Jefferson. Mr. Jefferson testified that he was working on scheduling the principal photography date for mid-April at the time that they submitted the third application. And he also explained that all of those communications on scheduling the additional shooting were verbal. So there was no written documentation of that other than the call sheet. And then there was one email that talked about filming in April. Judge Boggs determined that the department had acted appropriately in denying the appeal based on that additional evidence. So why does all that matter? We learned just last month when the department filed their brief in response to our petition, and that is, I'm going to put that up on the screen, that contrary to what the Judge Boggs had determined, the only reason for the denial of the third application was this conversation with the SAG representative. This is an excerpt from the brief, page 25. Here's why that's so damaging. Michael Jefferson, our witness, testified in the hearing that SAG wouldn't have even known about a change in the schedule for 6 to 8 weeks after the shooting had ended. So it was too soon for SAG to know about the change in the schedule at the time that Ms. Fibbin supposedly made the call to SAG. If the SAG representative had been called as a witness in the hearing, we could have established that through cross-examination, and it would have showed that the department's only basis for denying the application was false. So Judge Boggs' finding on why the department denied the third application turned out to be factually wrong. The real basis for the denial, which is the SAG hearsay, cannot be offered for its truth. And the right for any reason rule doesn't apply because there's not any other evidence of the March 25 principal photography wrap date. Now, relatedly, since the rule requires that the tax credit application be submitted before the end of principal photography, out of necessity, the principal photography wrap date listed in the application is only a projection.
Got about 6 minutes. Just want to interject.
Okay. So if you go back to the rule, it's the filming that is intended to be incorporated into the final project. And that date can change. So this is what this is exhibit 1 from the hearing. This is the film application form itself. And it says it's understood that the principal photography dates can change. So we had the call sheet that showed that the date had changed. We had the Jefferson affidavit that showed the date had changed. We had the application form. And then Mr. Capizzuto, Andrew Capizzuto, general counsel of the department, was asked in the hearing. He was shown a copy of the affidavit from Mr. Jefferson and asked if he had any evidence to contradict Mr. Jefferson's testimony that they had been trying to line up the additional days for principal photography, and he said no. So there is no other evidence in the record, and yet somehow Judge Boggs determined that Sam and Kate could not provide any evidence that it made substantive concrete plans for those shooting days. Mr. Jefferson's testimony, both in affidavit form, and he testified in the hearing as well, and was subjected to cross-examination. It is evidence, and it wasn't rebutted. And that testimony alone is enough evidence to carry the day under 2414-8. So all of the evidence in the record, the affidavit testimony, the hearing testimony, the third application, the call sheet, they all confirm an April 15 wrap date. Judge Boggs also erred in ruling that Sam and Kate had violated the rules by allegedly using the tax certification to raise money for the additional days of shooting. And I'm going to put the rule up for you here. It says that certification shall not be used to secure funding. Your Honor, that didn't happen here. The project was already fully funded at the time that the third application was submitted. That is undisputed. Fully funded, again, is a misnomer. It means 75% of the budgeted costs are in the project. So obviously the rules contemplate that an applicant may use the certification to obtain the additional 25% of funding required to complete the film. That is exactly what Sam and Kate did here. The second enumeration of error is that the ALJ erred in determining that the first and second applications were incomplete. The basis for that ruling was that the commitment letter from the lender was non-binding, and we respectfully disagree with that ruling. First of all, there was testimony in the hearing from John Thomas, who is a CPA. He testified that he had seen, he does this film tax credit work, a good bit of it apparently, testified that he'd been involved in over 100 of these. And in the past year, 4 of them had involved a commitment letter, just like the one that Sam and Kate submitted that had been approved. So that is that's testimony as to industry standards. The only objection to Mr. Thomas's, or the only explanation of Mr. Thomas's testimony, is that he was a lay witness, and the objection was that he was offering expert testimony. That's not true. He was offering testimony as a lay witness as to his personal knowledge. But even if it was an opinion, it would be admissible under the Handley case, 596 Fed Sup 3rd 1353, and that construes Federal Rule of Evidence 701, which is the same as the state court counterpart. The ALJ also erred when she found that the signed commitment letter is not enforceable. It was subject to New York law, Your Honor, and we did a deep dive in New York law. First of all, it contains all the essential terms of a loan agreement. It has a principal amount, and look, I'm sharing the screen again, interest rate, and a maturity date. Those are the essential elements of a note. And there are additional terms that evidence the party's intent to be bound. The lender is hereby pleased to provide you with the following terms. The lender will commit to extend. Talks about the financing that will be structured. Says in order for the lender to proceed to issue a binding commitment letter, you need to sign here. Most importantly, it contains a New York submission of jurisdiction and venue clause. So if the commitment letter was non-binding, the parties would not have been contemplated. There would be no litigation to be had over this commitment letter. So the parties clearly intended that it be a binding agreement, and under New York law, and all of this is in the brief, Your Honor, but the New York case law supports us on this. Your Honor, just real quickly, I don't want to forget why we're here. I know I'm running out of time, but
Yeah, you got less than a minute.
okay. The Georgia tax credit, the whole regulatory scheme, the whole statutory scheme, it's really a quid pro quo. The film companies come here, they shoot, they promote the state of Georgia, they provide jobs to people in the state of Georgia. In this case, Sam and Kate provided 150 jobs, temporary jobs. And the quid pro quo is in exchange for that, they get a tax credit. Well, here, Sam and Kate did that. They did their duty, they did their job, they created the jobs, and they've promoted the state of Georgia, and yet they have been denied this tax credit. We believe that it is arbitrary and capricious. We believe that the rules support us here, and that the decision ought to be overturned.
All right, sir. Thank you. Okay, all right. Respondents?
Your Honor, I'll be as succinct as I can be. I think just before addressing the specifics, I think there are 3 fundamental things to keep in mind that decide.
You got
this.
15 minutes, okay?
Okay.
All right. So
I'll do my
that
best.
doesn't
I'll do my
expand
best.
your time, all right? So,
Yes.
okay, all right.
I think there are 3 fundamental things to keep in mind. First is it doesn't matter whether we're talking about statutes, regulations, agreements between parties, or a lot of other things. You know, what the court's primary task is in this case, and the primary rule that we all live by as lawyers, is when you're interpreting a rule or a reg or a document, the first thing is you interpret the plain meaning of the words that are on the page. That's the alpha and the omega and the end of the discussion if those words are plain and there's no ambiguity. The second thing, I think it needs to be clarified because it wasn't quite fully explained in Mr. McGuire's presentation, is to understand the decision-making process here. When the Department of Economic Development evaluates these applications, that process starts when the application is received, but it doesn't really end until the general counsel of the department, Andrew Capizzuto, looks at their application on that final agency appeal. He testified that they're user-friendly. They want to work with people to fix errors in their applications. So it was kind of a continuum in this case that didn't end until that point. And finally, this has already been mentioned, but this is a tax credit. And in Georgia, Laws concerning tax credits are strictly construed against the taxpayer, and that's the Georgia Chemistry Council case, which we cited in our brief. So with that context in mind, we have three issues here. The first was the proof of funding. And again, as I just mentioned, let's start with the plain language of the rule. The plain language of the rule on proof of funding requires the applicant to present or demonstrate that it has assets which are either owned by the applicant or provided by a third party pursuant to a financing or funding agreement. That's a word that we can define. It has a clear meaning. Dictionary definition. I looked it up on Black's Law Dictionary yesterday. One definition I found on Black's was a financial contract or physical object, et cetera, et cetera. Assets are credits to the balance sheet. It may include cash, investments, accounts receivable, loans, et cetera. So it's got to be something tangible. What's the point of the rule? The point of the rule is to make sure there's enough money to pay people who work on the project. So we have to give effect to the plain meaning of that rule, which is they have to prove they have assets. What they gave us in the first two applications was a letter of intent. A letter of intent is not an asset. And the issue here is not whether that letter of intent could be enforced in court. The issue is the letter of intent itself an asset? And it's not. You can't borrow money against it. All you can do is sue someone in New York State. And if you win in that litigation, then and only then would you have the ability to borrow money. Well, that's not good enough for the purpose of this rule, which requires assets. And even if we want to get to the issue of whether or not this letter was enforceable, it wouldn't be, because it doesn't matter whether it's New York law, Georgia law, or any other state's law. We interpret the words that are on the page when we're looking at the party's intent. And in this case, it may have had a forum selection clause, but it also expressly called itself a non-binding letter of intent. It's called itself it said that it anticipated the execution of a final document. And most importantly, it said this document may not be relied upon by a third party, which is exactly what Sam McCade is asking to be done in this case. They're asking a third party, the Department of Economic Development, to rely upon a non-binding letter of intent. So I do not share Sam McCade's optimism that this thing would ever be enforceable, but the court does not ever need to get there. The court can just look at the fact that the letter of intent itself is not an asset. It is not proof that the funding is actually in place and people are ready to be paid. And for that reason, that issue was properly ruled upon by the administrative judge. The second issue, which I can address really briefly, Sam McCade asked that the first two, that the applications basically be allowed to relate back, right? So, well, then why can't we just consider them all a continuum such that they're all one big application that started when we submitted the first one? Well, there's an easy response to that, and that's the rule. There's no rule that allows for that. And the indications and the documentation all indicate that these are not a continuum. They're each a separate application act. Each application is separate. It's complete. It has a separate signature. It has a separate date. It repeats all the same information. There are no statements, no words on paper anywhere that indicate that these applications are supposed to relate back. And most importantly, when the Department of Economic Development told them after those first two applications that, their application wasn't complete because it failed to meet the requirements, that form email said, if you choose to reapply, then do the following. And it says no incomplete application will be accepted and no certification decision will be made on an incomplete application. So all the language leads itself to the construction given by the administrative law judge, which was that there's no support for a relation back theory. And finally, on that point, there is an additional rule of construction that we typically utilize when we're looking at statutes and regs. It's kind of the outer guardrails of construction. The core rule is plain language of what's there. The outer guardrail is we don't construe rules in a way that would lead to illogical results. We don't construe them in a way that's nonsensical or fails to harmonize all of the rules together. And think about what they'd be asking you to do. They'd be asking you to construe this rule in a way that if they all relate back to each other, then the deadlines really lose a lot of their meaning, right? Because you could file something as a placeholder and then come back much later, file something that you know is late, but since you filed a placeholder application before, it would relate back. So that's an impractical and unworkable application that needs to be avoided. So that relation back argument was also properly negated by the administrative law judge. The last issue that was taken up in this case was the primary one. Was this application in fact submitted late, the third application? And again, Your Honor, I think the ALJ in this case acted correctly when they started and ended with the plain language of the rule. And the plain language of the rule at issue here is 159.11.04 sub 1. And the rule says, the regulation says applicants must submit a completed certification application, ellipsis, before the completion of principal photography. And I think that's a date certain. And what it refers to is reality. Before the completion of principal photography, that can be interpreted. And that's before principal photography actually ended. And I think if we can distill Sam and Kate's argument to its essence, it is that don't make that deadline before it actually ended. Make it when the parties intended for it to end, or planned for it to end, or scheduled for it to end. And that has to be taken at face value. Well, we can dance around those questions and issues all day long, but that's not what the rule says. And I think significantly in this case, there is no factual dispute when principal photography ended. Sam and Kate's production representative at the hearing admitted it ended on March 25th, which was before they submitted that final application. There's no, and I know Mr. McGuire referred to some affidavits and some documentation that was submitted at various times, but there is no documentation, no affidavit, no physical evidence, and importantly, not even a contention from Sam and Kate that they were conducting any principal photography in Georgia after March 25th. It didn't happen. It simply didn't happen. So we know the date that it ended. And, this is another case where construing the rule to talk about, well, when was it scheduled to end? When was it planned to end? Obviates the purpose of the rule. The purpose of the rule is to make sure that those applications come in at the time the production ends, so that number one, they're spread out throughout the year. But number two, and most importantly, when these productions end, these are special purpose entities. When the movie's done, they fold their tents, they strike the sets, and they leave town. And the department wants to make sure that before everyone's too far gone and before the books are put away and everything else, that they have the opportunity to interact with them and evaluate the application. So allowing these applications to come in, months and months after production has ended would really hamstring the department's ability. So that's the reason for that rule, interpreting it so that it would be, well, here's when we have it planned to end, is a slippery, dangerous slope to go down. But most importantly, it contradicts the express language of the rule. Now, a couple minor points on that. First, going back to the beginning of the presentation, when I talked about the overall process, remember that, that decision about the final application date, that wasn't really finalized until there was an appeal before Mr. Capizzuto. So Sam and Kate had every opportunity between April 19th, when that third application was initially denied, and June and July, so 3 or 4 months, they had every opportunity during that time to kind of fix and cure that issue. And if there was in fact evidence that principal photography ended after the 25th, they could have submitted it, and they didn't. They did submit it. Didn't tell us that principal photography ended after that date. It didn't tell us the application was actually on time. And I think the quote in our brief was taken out of context. What that was referring to is an allegation that, when the decision was made back in April to first deny that application, that the department was somehow relying on information in previous applications, and they weren't. At that time, when that decision was being made, they were relying on that phone call. And relying on that phone call was a perfectly rational thing to do, regardless of whether SAG-AFTRA was right or wrong or had the best information or the worst information. Remember, the bar here is rationality. It is an extraordinarily low bar, extraordinarily. There just has to be some basis for that decision. And there was some basis. And it was, and most importantly, SAG-AFTRA was right. I mean, they turned out to get it exactly right. That was the date that production actually ended. But globally, that's not the most relevant thing. I mean, the most relevant thing in evaluating this is that wasn't the only chance that the department had to evaluate that assertion. The department had up until June and July. The department asked questions during the appeal process. We want to work with you. We want to help you. When did production end? You know, you're telling us it ended after March 25th. Okay, give me something. Give me something that shows me that, and we're golden. We're all set. They couldn't do it because that wasn't reality. And that's why the ultimate decision was made to deny their appeal. And the final agency decision was that the application was submitted late. You know, one last cleanup point, Your Honor. Mr. Thomas, the CPA who testified at the hearing, you know, I think we're kind of getting off the point when we talk about whether or not he had expert testimony. I mean, I think, first of all, he was never tendered as an expert. He was never qualified as an expert. So I don't know if we can retroactively designate him as an expert, but even if we could, expert testimony doesn't help them here, because the question isn't what is industry standard, right? The question isn't what's the industry standard for, and this is going back to the financing issue. What's the industry standard for accepting proof of financing? The question was, what does the rule say, right? I mean, we have to follow the rule, not the industry standard. And he may say, well, the industry standard is this or that, but the rule has a clear requirement that we don't need an expert to interpret, and the court only has to rely on experts when there's some kind of ambiguity or some kind of statement that requires expert testimony. In this case, the rule was clear. And the only reason his testimony was accepted was for his own personal experience as to whether or not the department was interpreting that rule in such a way as to expand the definition of asset to include letters of intent. And that testimony was weighed by the ALJ and found lacking in the face of the department's contradictory testimony. We can't reweigh it here on a judicial review. So that was a proper decision to reject Mr. Thomas's testimony and determine that the department was properly interpreting its own rule to exclude letters of intent. So I wanted just to clean up that last issue. I'm looking at my phone. I see I got about 30 seconds left. That was all I wanted to point out to the court. And unless the court have any ask that the decision of the ALJ be affirmed in this case.
Okay, all right. Thank you very much. All right, folks, let me just take a couple of minutes out. I need to kind of just consider a couple of things you told me. So, Ms. Donnelly, you can stand down just 1 second. I'll tell you when we're back on the record. Let's see. Chen versus J. Irie Properties, Mr. Wagner.
Good morning, Your Honor.
Good morning, sir. Sorry for the delay. It's just been a long morning, as you can see. Appreciate your patience. Have you heard from anybody from the other side?
No, Your Honor, I have not heard from him it's been a couple of months now.
Okay. What are you asking to compel?
Post-judgment discovery responses. We received objections to every single question that we asked. And the objections were based on some theory in the law that the judgment was forfeited.
Do you have an order? Do you have a proposed order for me?
I do, Your Honor. And we're also asking for attorney's fees to be assessed against both the defendant and his counsel because the objection is ridiculous. $885 in attorney's fees, which represents 3 hours of my time at $295 an hour, and then cost of $127.58, which is just the filing fee.
Okay. All right, if you'll send that proposed order to Mr. Kearns at the conclusion of our conversation, I'll go ahead and sign it and enter it, okay?
Thank you, Judge.
All right, thank you for your patience with us, all right?
Thank you.
Okay. Okay, last folks, Blasting Game versus Perimeter Property.
Good morning, Your Honor. Andrew Faulkner for Perimeter Property Services.
Alright.
Robert Dukes for Pass Split, Your Honor. Good morning.
All right, Mr. Dukes, are you representing the corporate entity?
Pad Split, Your Honor. Yes, Your Honor.
Are you an attorney?
Yes, Your Honor.
Okay, you're representing, and I apologize, so I just need to ask, okay?
That's fine, Your Honor.
Okay, all right,
I'm
no
not
problem,
offended.
no problem, no problem, okay, all right.
I think
All
as a
right,
compliment, maybe I don't look like an attorney.
No, not that. I just want to make sure, okay, because it's got Robert M. Dukes Williams LLC, and I thought I just conflated it. I thought it might be a realty company or something. So I apologize for that. Okay, all right, gentlemen, have you talked to Mr. Blassingame at all?
I have not, this hearing's been reset several times.
I know. I'm surprised he's not here this morning.
Well, he filed, he filed something at 9:04 this morning. It's a one paragraph, I guess, notice you would call it. I can read it for the court. I don't know if the court has access to what was filed this morning or not.
Let me see, Mr. Kearns, do we have it?
Or I can share my screen.
I'm checking right now, Judge.
Okay.
It essentially says he didn't get notice of this hearing and couldn't afford to get a copy from Odyssey.
When was the notice sent out to the parties, Wes? Did we get any bounce back from Mr.?
I've got it right here, Judge. The notice was filed on the 5th of July. And it went to his email address, which he has contacted me from, so.
Okay. Gentlemen, unless you have any objection to the contrary, I will dismiss his motion for declaratory relief and injunctive relief and damages, okay?
Works for me.
Can one of you prepare a suitable order to by the close of business today and send that to Mr. Kearns for me to enter?
Yes, I could prepare that. Do you want it? Do you want any findings, or did you just want it to say that?
You can say that. I would like you to say that the notice was sent out on the pursuant to Odyssey on the 5th of July, and the court has checked correspondence with this particular address and his prior correspondence with the court, and that we were in receipt after this calendar started at 9 o'clock, saying he asked for a continuance. But does he say why he wanted a continuance, Wes?
He claims he never received notice of the.
Okay, and the court is of the belief that he did receive notice and denies his request for a continuance and dismisses the complaint motion for declaratory relief and injunctive relief.
All right, I'll get that over to Mr.
Something to that nature, Mr. Faulkner.
Get
Mr. Dukes, anything you want me to add? You want me to add anything, Mr. Dukes?
No, Your Honor. The only thing I was going to mention is, much like you've been doing already today, you actually mentioned it last time we were in court about August the 10th. So he had actual notice because, Mr.
Yeah, I give in court notice, but ordinarily I do want to send out a written notice because that's
Understood.
just the way that we do business. So, yeah.
Understood, Your Honor.
Especially with pro se parties, just to make sure that they have something else that I can tell all of you who are lawyers and you all are bound by that. But, with pro se parties, it's just better for me to send a notice and it's just more appropriate.
Understood, Your Honor. So
okay.
nothing.
Right. Yeah, and gentlemen, unless you don't have anything else, I appreciate your patience, and Mr. Faulkner, send that to Mr. Dukes and to Mr. Blassingame, and just as a matter of course, and then I'll sign the order and enter it. Okay.
I'll get that done right now. Thank you.
All right. Thank you. Unless you have
Your
anything else, I'll excuse you. All right, folks, I'll be with you in just a minute. All right, folks, thank you for your patience with me and this morning as well, given our technology challenges at all. Okay, folks, you can turn on your cameras if you like at this point in time. I think I'm in a position to give you a decision. Wait on Mr. McGuire.
I think Mr. McGuire may have stepped out of his office very quickly, but I'm here so we can proceed.
And you are Miss Colson?
I'm Miss Colson. I'm his law partner. I apologize.
Okay, all right, that's okay. All right.
Sorry, I'm back, Your Honor.
Okay, and where's Miss Mate?
Sorry, I'm here.
That's all right. Don't worry about it. Don't worry about it. Okay, folks, listen, I wanted to take a look at a couple of things, and you know, in doing so, and I appreciate your patience with us as you know, we've had a full kettle of fish to fry this morning. So want to make sure I gave your matter the attention it deserves and you expect as advocates and litigants. Listen, I've had an opportunity to kind of, like I said, consider the record in this case, and you know, I believe that the argument and the reason for the appeal, or one of the reasons for the appeal, is that, you know, alleging that the ALJ was you know, the decision of the ALJ was arbitrary and capricious and didn't follow the appropriate law. I believe that is, I'm not going to follow that. I'm going to leave it as is ruled upon. This is a very you know, important issue, and certainly if you wish to take any further review from this court's ruling on that, then I think that would be appropriate under the circumstances. But I've had a number of these cases, and there's very little that I can I can't reweigh evidence, and I certainly can't I can't superimpose the court's own opinion on that. So I am going to deny the appeal at this point in time, and invite you to take any other action from it. Okay.
Thank you, Ron.
Okay. So Mr. Stay and Ms. Mayton, if you would prepare a suitable order, and you can float that to Mr. McGuire and Ms. Colson, and then if you could get that to us by next week, Tuesday, will that give you enough
Yes,
time?
Your Honor. Yeah,
Okay.
I'm speaking only for myself. I don't know. Matt, is that good for you?
Sure, that works for me.
Okay.
All right.
And then once we enter it, you all can do it what you choose from there. Okay.
Yes, thank you, Your Honor.
All right. Do you have any other business before me, counsels?
No, sir, Your Honor. Appreciate
Okay.
your time.
For us.
No, if not, then I'll wish you all the best and be well. Okay.
All right. Thank you, everyone.
All right, you're welcome.
Thank you, Your Honor.
All right.
Bye-bye.